Are you a U.S. citizen parent looking to get citizenship for your permanent resident child? Or are you the permanent resident child of a U.S. citizen and you want to know, am I already a citizen? Can I just get my citizenship and move forward with my life? Or do I have to go and apply for naturalization? Well, in this video, I am going to break all of that down for you, why it matters, what you need to know about it, and how to go about the process. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. Being automatically a citizen makes such a difference in people's lives. When you are a permanent resident, your residency can be terminated. You can be put in immigration court proceedings and potentially get deported. But once you are a U.S. citizen, it takes so much effort on the part of the U.S. government to actually take away your citizenship. So it is so important that once you qualify for citizenship, whether you yourself or your child qualifies for citizenship, that you are applying for that citizenship immediately so that they do not fall into any unforeseen traps that can lead to them not being able to get citizenship or potentially being deported. A place that we see this often in our practice is where a child of a U.S. citizen that's a permanent resident unfortunately gets into a situation where they are arrested and convicted of a crime that makes them deportable and ends up in immigration court and is deported. But what if we can prove that that child is already a U.S. citizen? A U.S. citizen is not deportable just because they committed a certain crime. A permanent resident is deportable for certain crimes, but that does not apply to a U.S. citizen. So if we can prove that that child of a U.S. citizen is actually a U.S. citizen, the U.S. government cannot put them in deportation proceedings. They cannot be deported. So that's why it matters to figure out whether you are already a U.S. citizen, whether your child is already a U.S. citizen, if they end up, unfortunately, in a situation where their permanent residency is in jeopardy. The first thing we need to do is figure out what law actually applies to you or your child at the time they turned 18. So that is the key here. What law applies to them? And I have done this for people born in the 1930s and we're able to get them citizenship. So this is really the key. What law was in effect when they turned 18? And do they qualify for citizenship based on that law? If they do, then that's what we're going to use to prove that they qualify and make sure they get their citizenship. Like I always tell you all, immigration law is complicated. It changes, and we need to keep up with the changes. I will be focusing on the last law, when the last law was passed. And that's going to be the focus of this video. If you think you may qualify and you are from a time before the current law, or your child turned 18 or 21 before the current law, go ahead and reach out to me and I will be happy to walk you through the requirements. And if you do qualify, we can talk about how to help you. This video will be extremely long if I go through each of these requirements in detail, but just know you want to make sure that if you think you meet the requirements, schedule a strategy session. Let's confirm that and let's get you on the path to being able to prove your citizenship and getting documentation that shows that you are a U.S. citizen. You can schedule a strategy session with me by going to my website, lilylegal.com, and clicking on Contact Us. Or you can call my office at 508-443-1788. There's different date ranges because there's different laws that apply at those times with their different requirements. I'm going to just go right here to the last one, which was from February 27, 2001. So anyone that met this requirement on or after that date is a U.S. citizen. Okay, so the requirements I'm about to go over, if you met them on or after February 28, 2001, you are a U.S. citizen. Okay? So let's talk about it. And then I will be going deeper on some of these because it does get tricky, the wording, the things you need to show. Okay? So let's start with the first requirement. One of the child's parents must be a U.S. citizen, either by birth or by naturalization. The second requirement is that if the child is born out of wedlock, if the child is born to parents that were not married to each other, the mother has to be the U.S. citizen. But if the father is the U.S. citizen, then the father has to show that they legitimized the child, or the child, if the child is filing, has to show that the parent, the father, legitimized them. Okay? And that's legitimization either based on the laws where the child resided or where the father resided. And this legitimization must take place before the child turns 18 years old. Basically, every single requirement here has to be met before the child turns 18 years old because that is the cutoff year. Once the child turns 18 and they have not met one of these requirements, they do not qualify. They are not a U.S. citizen. Next requirement, child is under the age of 18 years old. Now, I'm just going to take a minute here to tell you that when it says child is under 18 years old, it means that the child met this requirement before they turned 18 years old. It does not mean that the child is currently 18 years old. So this is a wording that I just want to make sure that it's clear to you, is that the child met every single requirement here before they turned 18 years old. It does not mean that the child has to be 18 years old now to qualify. Okay? The child is unmarried. Again, that is the child is unmarried when they met all of these requirements. Not that the child is currently unmarried. So, as far as the age, I've done this for 30-year-olds. Okay? I've done this for married people. However, they met all of these requirements. So at the time that they met every single requirement here, they were under the age of 18 and they were unmarried. What happens after that? Not our concern. Okay. Whether they got married, now they're over 18, that's perfectly fine. Okay. The key here is that they met this requirement, right? They were unmarried when they met all of these requirements. The child is a lawful permanent resident or national. That means they have a green card or they were born in a U.S. territory that makes them a U.S. national but not a U.S. citizen. And then the final requirement is that the child is residing in the U.S. in the legal and physical custody of the citizen parents. Listen, they specifically said in the U.S. because there's a different form for children that are outside of the U.S. I'll be talking about that in the next video. When it comes to legal custody, there are 5 situations where USCIS will always find that the parent has legal custody of the child. 1, both parents have legal custody if their biological child lives with them. The parents are married to each other and are not currently separated. USCIS will always find that both parents have legal custody of the child. 2, a parent always has legal custody if the biological child lives with her and the other parent is deceased. USCIS will always find that the parent that the child resides with has legal custody. 3, if the child is born out of wedlock, the parent has legal custody if the parent lives with the child, the parent has legitimized the child before the child turned 18, according to the laws of where the parent is domiciled, or the child is domiciled, meaning where they live. 4, both parents have legal custody if they are divorced or separated, and the separation agreement, the divorce judgment, gives both of them joint legal custody of the child. Alternatively, 5, A parent has legal custody if they are separated or divorced from the other parent, and the court has given them legal custody of the child. This is where there's sole legal custody of the child to one parent. That one parent has legal custody of the child, while the other one does not. Finally, there is room in the rules where USCIS can find custody, legal custody in other situations. This is where we can be a little creative in our argument of legal custody if you do not fit into any of the other 5 that I have discussed. When it comes to physical custody, USCIS relies on state law. What does your state say about who has physical custody of the child? If you, the U.S. citizen parent, has the physical custody based on the state law, then USCIS will find that you have physical custody. So that's another reason that we do this analysis. We look at the state laws at the time that the child would have met all these requirements to make sure that you did have physical custody of the child according to your state law. Everything that I have been talking about is on case-by-case basis because each person's situation is different. The way you meet the legal and physical custody requirement is going to be a little different, but you want to do the analysis. We do the analysis for you to make sure that we are looking at not just did you meet the legal custody requirement, but what does your state law say about the physical custody requirement? And we look into all of that for you to make sure that you are meeting the requirements and you can get citizenship through your parents, or you can get citizenship for your child. For adopted children, they can still qualify to get derivative citizenship if they meet these 2 additional requirements. They were under the age of 16 when they were adopted, they were in the legal custody of their parent, and they were in the physical custody, meaning they resided with the parent for at least 2 years. They will be able to qualify. Again, remember, all of this has to happen before the child turns 18. So that 2 years of residence together for an adopted child has to take place before that child turns 18. Now, like I said before, if you were born before February 28, 1983, these are not the requirements you need to look at. These requirements are only for people born on or after February 28, 1983. If you were born before that, you will need to look at these other parts of the chart, okay? These are the parts that you will need to look at because that is where the requirements are for you, okay? The requirements change depending on when the laws change, you know? So I'm going to leave this here so you can take a screen grab and be able to look at that for yourself. If you think that you are a U.S. citizen, but you're not sure if you meet all of these requirements, schedule a strategy session. Let's talk about it because we can do an analysis to see if you are a U.S. citizen already and what documentation we will need to help prove it. We have done a lot of different things to get records from parents, even when parents are deceased, to get information so that we can prove that a U.S. citizen is a U.S. citizen, right? So really think about if you were born, like I said before, February 28, 1983, you're going to have different requirements than what I just went through. If you are watching this video and you think you may be a U.S. citizen or your child may already be a U.S. citizen, go ahead and schedule a strategy session with me so that we can really find out if they are already a U.S. citizen, if you are already a U.S. citizen, and what steps we can take to make sure that you have documentation to prove your citizenship. You can do that by going to my website, lilylegal.com, and clicking on the Contact Us and scheduling a date and time for us to speak. You can also call my office at 508-443-1788. You should not feel like you have to figure this out on your own. That's what I'm here for. You come to me, we figure it out together, and figure out the next steps that needs to be taken for you or your child